State of Arkansas versus Robert Hadley. There's 2013-34, 2013-232, and then there's a revocation proceeding, I believe, or is that not a revocation? It may not be a revocation.
There are two new charges and a pending charge. The pending charge, Mr. Dillinger represents me, has written a letter asking to be excused today. He's filed a motion for continuance in that case as well, which your office should have. But the other two cases he's not involved in, so I don't know how if he intends to employ Mr. Dillinger or how this is going to go forward.
My understanding is Mr. Hadley has made application to the Public Defender's Office in relation to those two cases
Yes.
at this time. I'm going to deal with 2013-62 first. It's set for trial November 12th and was down for pretrial, but pretrial has been continued, I guess, to this date. Matter is set for trial November 12th. I'm granting Mr. Dillinger's request for a continuance of the pretrial hearing, and this matter will remain on the trial docket set for November 12th.
Judge, for judicial economy, would the court consider putting all of these cases on the same docket? Since it's on your docket, you taking all of these?
Well, I don't have. Yeah, I mean, they're already assigned to the same docket. All three of them are on my docket to begin with. As the record reflects at this point, Mr. Dillinger is representing Mr. Hadley on 2013-62, and I've reviewed the affidavit in regard to appointing counsel in the other two cases. It's my understanding that Mr. Hadley qualifies for representation, and I'm going to make the appointment of the Public Defender's Office in regard to the two new cases. I am a little uncomfortable with a circumstance where a defendant has employed counsel on one case and is asked appointment of counsel in the other two cases, but I'm going to go ahead and do that because there's quite an extensive period of time between the initial appointment and the
we can leave the existing case, the pending case, on the trial docket because it's ready to go. These are not going to be tried together. The only reason to have them on the same docket is for plea purposes.
Right. Yeah. So with regard to 2013-62, it's just down for trial.
Yes, sir.
I've noted Mr. Dillinger's request and excused him for appearance here today, and continued any hearings that were to be taken up today. The matter's still down for trial November 12th. On the two new cases, having appointed the Public Defender's Office, I'm making they're for arraignment here today.
Your Honor, we'd enter a plea of not guilty on both of the new cases, waive formal arraignment, reading of the charges.
And both of these cases will be set down for trial April 21st and 22nd.
Planning discovery.
Pre-trial will be scheduled for March 6th, 2014, and reappearance will be ordered for February 6th, 2014.
Your Honor, even though there was uncertainty since Mr. Dillinger is involved in one of the cases, I did visit with Mr. Hadley enough this morning that I would like to address the issue of his bond on his two new charges.
just writing, so please go ahead.
That's, Your Honor, I believe, and I'm relying on Mr. Hadley for this information, that on the two new charges, he has a combined bond of $25,000.
That's correct.
This gentleman is age 46. He has lived in the Cotter area for 13 years. He owns his own home. He is fully disabled from an injury that resulted from an accident, a frontal lobe type injury. Your Honor, I do not know Mr. Hadley that well. I will tell the court that in dealing with him this morning, I believe that he fully understands his requirements to reappear in court. I don't consider this gentleman to be of any sort of risk, considering the charges, considering the personality he's displayed to me this morning, and I would ask for a reduction to $5,000 on his bond.
Judge, the only problem the state sees is this man has continued to engage in a course of conduct involving controlled substances, which indicates he has an inability to control his involvement in that. I don't know if he has an addiction to the controlled substance or to the money that comes from that, but it appears to me that he's a user of controlled substances as well. And I don't know if that's going to be in his best interest. I think if he's going to make a bond, would not oppose some reasonable bond, but I think he needs to be introduced to a rehab program or something to be sure that he's not going to just reoffend and we'll have him right back in jail again.
You know, we certainly don't object to the usual condition the court imposes on bonds in this nature, that total abstinence from any alcohol or drugs, possession or use. And would understand that if he's in simple possession, that would be a violation of his bond.
Judge, I'm suggesting a rehab program, and then they bond out to a rehab program. If he successfully completes that, then he can go home. That's my suggestion, because if he doesn't deal with his controlled substance problem, it's my belief he'll reoffend. But it's certainly that's a risk with everybody in these kind of cases.
We'll see. Your Honor, if we could get him evaluated by Omar, and if the bond is set at the requested amount, either an inpatient or outpatient, depending on what Omar recommends, I would have no objection to that, Judge.
Well, it's going to be set at $5,000. That's going to be conditioned upon him being evaluated and entering and following through by entering and completing the rehab program, program. If he's not, in other words, the bond is conditioned upon him going through the rehab program. Once he's completed the rehab program, he'll be subject to, successfully completed, he'll be subject to continuance on that same bond without having to return to incarceration. And of course, a condition of the bond will be that no use, possession, or other participation in with any drugs or alcohol.
Can we go ahead and get the trial settings this time too, Judge?
I'm setting it, both of these cases, for April 21st and 22nd. Pretrial is March 6th, and reappearance is February 6th. 2013-235, State of Arkansas versus Terry Stacy. Court is making the appointment of the Public Defender's Office based on the affidavit submitted. C is for arraignment on charges of possession of methamphetamine, Class D felony, possession of drug paraphernalia, Class D felony, and residential burglary, Class B felony.
Your Honor, on behalf of Mr. Stacy, we would enter a plea of not guilty to all charges, waive formal reading of the charges, and waive formal arraignment. Your Honor, Mr. Stacy, like several others that have appeared and will appear in front of the court today, is currently being held on a parole violation, so bond is not an issue, at least today.
This matter is on Judge Putman's docket. I'm setting it down for reappearance on October 31st in front of Judge Putman.
Why not talk about 21st?
You may be excused, sir.
Judge, I'm gonna put the court on notice, since it has drug court. I've offered this defendant drug court. The drug court probably be instituted after he completed his revocation on parole. These charges stem from simple drug possession. That's been this man's problem for some time, and we'll have him screened at the appropriate time to see if he'll be accepted into drug court. I do not know that he will accept the drug court plea, but if he does, we'll do the screening and go from there.
Very good.
Sound might be good, right?
Defendant may be excused at this time. 2013-237, State of Arkansas versus Paul Langford. Court will note that the court is making the appointment of Public Defender's Office to represent Mr. Langford.
Your Honor, we'd enter a plea of not guilty on behalf of Mr. Langford and waive formal reading of the charges and arraignment.
Plea of not guilty is noted.
Your Honor, there's also a hold on Mr. Langford. He and I visited this morning, and he's aware the bond is not an issue today.
I'm ordering his reappearance in front of Judge Putman on March 31st. October 31st. Thank you. You may be excused, sir.
Thank you.
2013-238, State of Arkansas versus Antoinette Wilcoxon Dobson, charged with filing a false report. The court is making the appointment of the Public Defender's Office.
Your Honor, plea of not guilty on behalf of Ms. Wilcoxon, waive formal reading of the charges.
Plea of not guilty is noted. Course of the case will be set for trial.
Judge, this is-
April 21st and 22nd of 2014. A pretrial hearing will be scheduled for March 6th of 2014, and a reappearance will be ordered to check the status of the case for February 6, 2014. Now,
Your Honor, there is no issue of bond on this matter. Once again, this is a parole violation situation.
all right. That'll be the order of the court. Ms. Dobson, you need to stay in touch with your counsel. If you do bond out, you need to stay in touch with your counsel.
Yes, sir.
Your next reappearance in court is February 6, 2014.